Okay, we're ready to start. Subcommittee Chair, Senator Spruill, will report on the bills that went to the Energy Subcommittee along with recommendations.
Thank you, Mr. Chair. Mr. Chair, members of the committee, what I tried to do is to be fair that those things that could not be worked out, I tried to make sure that all the stakeholders meet together first. If not, then we will recommend the people by the bill. First one, Mr. Chairman, is House Bill 73. Amend certain provisions related to the Airport Control Board regulation of carbon dioxide commission. The bill removes certain requirements for energy efficiency pilot programs to be considered for the program. After thoroughly viewing this and having people to testify, the committee recommend 3-1 to PBI the bill. I so move.
All right, there's been a motion and a second to pass by indefinitely House Bill 73. All those in favor of passing it by indefinitely, vote aye. Those opposed, nay.
Ayes 7, noes 5.
Ayes 7, noes 5.
Thank you.
Bill is passed by indefinitely.
Thank you, Mr.
All right.
Chairman. Next, Mr. Chairman, is
74.
House Bill 74. Identify the EITE, which represents energy intensive trading exposed industry. The bill directs the State Corporation Commission to establish this commission to exempt pilot program for non-taxable charge. This, Mr. Chairman, that we had some difficulty on trying to decide this because stakeholders have not heard this. So I told them the committee want to PBI the bill, but as I said before, I want to be able to have some folks to be able to meet on this. And I had one gentleman there come by and said it's been worked out. And I had Dominion come by who had one way or the other, and I had 3 groups, Mr. Chairman, that come to me and said that no one had involved them. And I said, Mr. Chairman, you made me chairman of the subcommittee. And so when folks come by and don't talk to me about it, they work it out, but I have not. And because 3 groups have come to me and said they have not been involved in that. So I'm trying to let people understand that Mr. Sasslaw, I'm gonna call you Mr. Senator, made me subcommittee chair. And because they have not, and I talked with members of the committee, we recommend to PBI this bill. I so move.
Okay, did you hold an actual hearing?
Yes, sir.
You did? So
Yes, sir.
there's no need to that.
Yes,
All right,
ma'am.
you've heard the motion on House Bill 74 to pass
Chairman.
by indefinitely.
Mr. Chairman.
Senator Newman.
Mr. Chairman, I think the subcommittee chairman has always got that right. There was no recommendation on the bill. I do believe the bill holds a great deal of value, especially for a lot of the manufacturers in Virginia. I wish there had been communication that had been worked out, but I don't know if that's possible or not. But this bill, it can go up or down, but it just seems to me it had the potential for holding a great deal of value.
Mr. Chairman, I had the gentleman come by and said to me that it's been worked out. But I'm saying it's fine, but no one has sit down with me. You asked me what's been worked out, Mr. Chairman, I cannot tell you. I had Dominion came by and I had people from the Clean Energy came by and 3 other groups said to me that you said, Mr. Chairman, is that you want all stakeholders to be involved in it before you heard this. And we have not been there. And I'm saying because they have not, Mr. Chairman, unless you rule otherwise, because they have to meet with me just telling me it's been worked out, and groups say they have not been worked out and have not been worked out. I should say otherwise. Again, I've been moving motion to PBI the bill.
All right, there's a motion to pass by indefinitely. Is there a second? Second. All right, a motion and a second to pass by indefinitely. All those in favor of passing House Bill 74 by indefinitely, vote aye. Those opposed, nay.
Ayes 9, noes 4.
Thank you, Mr. Chairman. Next, Mr. Chairman, is House Bill.
74 is passed by
Thank you.
indefinitely.
Next, Mr. House Bill 1.
Mr. Chairman, I apologize. That last bill, having voted on the prevailing side, is it possible we could reconsider that so a member could correct their vote?
Sure. All right, you've heard a motion to reconsider the vote by which we passed by indefinitely House Bill 74. All those in favor of reconsidering the vote, vote aye. All right, bill's back before us.
Mr. Chairman, can I ask the bill go by just temporarily, just to make sure there's not some way to get a thumbs up that we worked it out?
Mr. Chairman,
I can do it till the end of this, but then we've got to get going. All right. till the
Mr.
end
Chairman,
of, the
no
manager report.
disrespect to what the gentleman is saying. Mr. Chairman, as again, as I have said to all the commission that you made me subcommittee chair. And I'm saying because of that, and I asked the stakeholders to please come by and see me to explain, not just saying you worked it out. And when the groups come to me and say they have not been involved in that, I'm just doing it as your director, as the subcommittee chair, it has not been done. So I understand what he is trying to say, but it has not been done. I still remove my motion to PBI the bill.
All right. Motion and a second to pass by indefinitely House Bill 74. All those in favor of passing by indefinitely, vote aye. Opposed, nay.
Ayes 11, noes 2.
Thank you,
Ayes
Mr.
11,
Chairman.
noes 2.
Next, Mr. Chairman, is
74
House
passed
Bill
by
112 by Delegate Kilgore. It's grant authority to the State Corporation Commission to designate a commercial mobile radio and cellular phone service. This was discussed thoroughly by the commission. There was no opposition on either side, and everybody was kumbaya, was in favor of it. So I moved this bill report. It was to recommend support 4-0. I so moved.
Okay. The recommendation is to report House Bill 1112. All those in favor, vote aye. Opposed, nay. Hold on. Hobie, is everything good to go? We're good. All right.
Adams, you good to go?
The motion is to
Report.
report House Bill 1112. All those in favor of reporting House Bill 1112, vote aye. Opposed, nay.
Ayes 13, noes 0.
It's not recorded.
Servelt would have voted aye. Is that correct?
Senator Sherville gave a list of his votes to Senator Bell, but we're not sure if he pressed the machine properly. Just do that. You wrote it down. Thank you.
Thank you, Mr. Chairman. Next, Mr. Chairman, is House Bill 118.
That's Freitas.
Yes, sir. House Bill 18, Mr. Chairman. It was
118.
I'm sorry, thank you. Was to repeal provision requiring the State Air Pollution Control Board to adopt regulation to reduce carbon dioxide emissions from any electrical generating unit in the Commonwealth and authorize the board to establish an option program for energy for allowing the State Corporation Commission from approving this commission. We investigated this thoroughly. It was so moved by the committee 4-1 to PBI, and I so moved.
All right, you've heard the motion and a second to pass by indefinitely House Bill 118. All those in favor of doing that, vote aye. Those opposed, nay.
Ayes 13, noes 2.
Ayes 13, noes 2. House Bill 118 is passed by indefinitely.
Mr. Chairman, next was House Bill 396. Mr. Chairman, I think we have to move it in adoption. We have an amendment on that, I believe.
There's a subcommittee amendment.
Yes, sir.
Okay, all those in favor of adopting is it a substitute or an amendment? Line amendment.
Mr. Chair, Senator Spruill, it's one technical amendment correcting a code reference.
Okay. Those in favor of accepting the amendment, say aye.
Aye.
All right. Amendment is accepted. Go ahead.
Thank you, Mr. Chairman. It's update provision related to American Electric Power participation in a municipal energy program. The bill clarified that the program will be done, and however, was a pilot program, and we, in thoroughly investigate this, Mr. Chairman, it was moved 4 to approve and 1 abstain. I so move.
Okay, you heard. So the motion is to report House Bill 396 as amended. All those in favor? And the subcommittee recommended 4-0 to 1 abstention. All right, those in favor of reporting House Bill 396, vote aye. Those opposed, nay. I thought I did. Okay.
Ayes 15, no 0.
Next, Mr. Chairman, is House
15,
Bill
0, it passes.
Yes.
405.
405, Mr. Chairman, 405, Mr. Chairman, amend the definition of business park by adding that a business park may be established by locality by removing the requirement that a business park be located in an area of Commonwealth designated as an opportunity zone by the U.S. Secretary of the Treasury, Mr. Chairman. The bill requires that a location of the qualifying project for an existing pilot program to promote economic development in the Commonwealth by allowing Dominion Energy and Appalachian Power to complete the construction phase of electric transmission infrastructure by up to 3 business parks prior to the business regulation. This was vetted close by the committee, Mr. Chairman, and so I move report. It was 5-0 to report. I apologize. Yes, Mr. Chairman, do have an amendment.
All right, we need to adopt the amendment.
I so move.
It's been moved and seconded, we adopt the amendment to House Bill 405, Delegate Ballard's bill. All right, all those in favor of adopting the amendment, say aye. Aye. All right, amendment's adopted.
Now I so move that we report the bill,
And the
please.
subcommittee recommended 5-0 that it be reported. All right, all those in favor of reporting 405, vote aye. Opposed, nay.
Ayes 15, no 0.
Ayes 15, nay 0. All right, 894.
Yes, sir. Mr. Chairman, 894, Mr. Chairman, was passed by the committee to approve, but there was some problem with it. Some technical lines that was taken on line 14 and 15, and I would, the clerk would please address those lines, please.
Mr. Chair, Senator Sproul, if you look at the original the bills that came over from the House, the subcommittee discussed a substitute that removed everything in the bill other than the enactments. But I think what the subcommittee, or that's what I heard, I think what the subcommittee's intent was actually everything in the bill and the second enactment taken out, leaving just the 3rd through the 6th enactment. And then I believe Ms. Delegate Kilgore asked for some changes to the last enactment, and that substitute is now available online.
With that, Mr. Chairman, unless someone is in opposition of it, that those substitutes was welcomed by the committee to report.
Mr. Chairman, I have a question.
Senator Bell.
Thank you, Mr. Chairman. This is a council. What was the part that was stricken from the bill? Is that the part that was dealing with solar?
Mr. Chairman, we have Delegate Kilgore here. You got it? He got it, I'm
The
sorry.
part that was stricken from the bill, Senator, is the language repealing Section 30-209 of the Code of Virginia and language from the VCEA that directed, that said to wait until a report was completed before declaring certain facilities in the public interest.
You're saying that was deleted?
Yes, sir, that language is no longer in this substitute that's being offered now.
Mr. Chairman, I think that's the part that deals with solar, and I see the patron Webb, put his head up and down, so I think we're good to go.
Mr. Chairman, I was having one opposition, so since that was deleted, that those who were in opposition, anyone, because that was one concern that the opposition had, Now, that's okay now? So thank you, Mr. Chairman. The opposition waved their hand thumbs up. So thank you, sir. So now with that, Mr. Chairman, I move the approval of the bill.
All right. You've heard-
Yes, we did adopt the sub. If not, I so
No,
move the sub.
We haven't adopted, all right, you've heard the motion to adopt the sub. All those in favor, say aye.
Aye.
All right, the bill as a sub is before us. Just take a look at the,
Report, Mr. Chairman.
Okay.
Report to refer to
Motion to
a portion.
report.
Appropriate. I hate to say that word appropriation, you know that.
894 is a substitute.
Yes, sir.
All those in favor, vote aye.
And to report.
I said to report.
Oh, sorry, thank you.
Okay.
Ayes 14-0.
Okay.
Mr. Chairman, House Bill 1204. That one, Mr. Chairman, we had some work to be done, and I asked Delegate Kilgore, it was the amount of technical on this thing that he could come to us and explain this. Mr. Chairman, I certainly appreciate it.
Okay, so you didn't have a hearing.
We had a hearing on it, Mr. Chairman, but there was some technical form that we worked it out. Mr. Chairman, that case then, you got to come and please explain it, sir. Thank you.
Yeah, just one minute or half-minute explanation.
We worked it out. This was we were looking at renewable, we were looking at the
Renewable energy
regs for solar and also looking to put solar more in the tobacco region or in the brownfields regions of the state, and that's basically what the bill does now. And also addressed, was able to come up with a language that would address the out-of-state regs and let the state corporation basically look at that, Mr. Chairman.
Mr. Chairman, do we need an amendment? Is there an amendment on that?
Mr. Chairman, Senator Sproul, Delegate Kilgore just explained the substitute that is available online, but you would need to adopt it.
All right, I also move, Mr. Chairman.
All right, motion and second to adopt the substitute to House Bill 1204. All those in favor, say aye. Aye. All right.
Now, Mr. Chairman, with the substitute, I move to approve as the substitute, House Bill 1204.
All right, all those in favor of passing House Bill 1204 as a substitute, vote aye.
Ayes
Thank you.
15-0.
Mr. Chairman, the last one that I had some heartburns on, again, trying to work out with both sides. Now, Delegate Kilgore came by my office and we talked about this bill, and I had him that was so close that no one wanted to say yeah or nay on it, and I asked him to come to the committee very quickly to explain this in short form. Delegate Kilgore?
I have a substitute that, it's an amendment, and basically it took out the fact that they would get a rec for using the waste coal because they already get their fuel paid for anyway, so they didn't need that. We're just saying that removal of waste coal is in the public interest, that gob coal, but, and that's basically all the bill does now.
All right, Mr. Chairman, so I move the substitute. The amendment, I apologize.
I think it's an amendment, right?
Yes, sir.
All right, all those in favor of adopting the amendment to House Bill 1326, say aye. Opposed? All right. It's
Mr. Chairman, now, the one person who had the objection to it, are there anybody here that an objection to it now? No one is in objection to it? Yes, sir, please. I had to them, I will allow them the opportunity to speak.
Yeah, Mr. Chairman, thank you. Bob Shippey with Sierra Club. The bill is vastly improved. I think it still says that burning this waste coal is in the public interest, and that is the remaining piece that we would object to. Thank you.
Yes, Blair Sandler, also with Climate Cabinet, to uplift Bob Shippey and Sierra Club's
With who?
Climate Cabinet, to uplift those comments. This body has passed 2 study bills to deal with this over the next year, and passing something that establishes that burning this is in the public interest prior to getting the result of that study is premature, and we should pass this by for a year. Thank you.
Thank you, ma'am.
Mr. Chairman, question. I know we passed Senator Hackworth's bill, SB 120, coal, waste coal piles. I don't know if the patron perhaps we could conform this to Senator Hackworth, and then they go to conference and work it out.
If that's what the committee desires to do. I'm just trying to address
What was the
that.
difference in his bill?
There's a number of differences, what I can tell, but I think it goes to the same intent. It passed the Senate 40-0.
Yeah.
And, so there was nothing really objectionable in that bill.
All I'm trying to get at, to Mr. Chairman, is trying to clean up the waste coal that's there, and
Does Hackworth's bill do that?
I think in time, it will. It studies it, yes.
Okay. All right, you've heard the motion of adopting this to Senator Hackworth's bill. All those in favor say aye.
Aye.
All right, and if you want, we can go to conference, whatever. Okay.
Thank you, Mr.
You
Chairman.
bet. All right, all those in favor of adopting the substitute to House Bill 1326, reporting, House Bill 26 as a substitute, vote aye.
Ayes 15, no zero.
All right.
That's all I have, Mr. Chairman. Thank you.
All right, thank you for the job you've done. All right, we've got two bills that are in the identical category. One is House Bill 270, it's Delegate Byron's bill. And that passed the committee 14-0-1 with there was one abstention, and it passed the floor 40-0 in the Senate. This bill is identical to that. And that's right, Mr. Tom Stevens?
Mr. Chair, House Bill 270 came over to the Senate a little bit different than Senator McPike's bill, but the bill first went to general laws and they conformed it to Senator McPike's bill, and so it is identical before you.
All right. All those in favor of reporting House Bill 270, vote aye. Those opposed, nay.
Ayes 15, no zero.
Ayes 15, nays 0. The bill is passed. The last bill that is identical is House Bill 312. That's identical to Senate Bill 469, Senator McClellan's bill, which passed here 15-0 out of this committee and the Senate floor 40-0. Do I hear a motion? So moved. All right, there's been a motion to report House Bill 312. All those in favor vote aye. Those opposed, nay.
Ayes 15, no zero.
Twice reconsider, twice is only twice. All right, the first bill will be HB 44, and that's Delegate Ware. Standard non-forfeiture provisions for life insurance, minimum non-forfeiture amounts, interest rates. Passed the House 99-0. Okay. All right, you're up, Delegate Ware.
Thank you, Mr. Chairman. This is a very simple bill that comes to you at the request of the Bureau of Insurance of the SEC. It is dealing with deferred annuities, individual annuities. It's a retirement planning tool, and I can give you the details, but I expect most of you have an idea about that. The relevant point in the bill is that it would have a minimum interest rate that as it is regulated by statute. Currently, the minimum rate is 1%. The bill would lower that minimum interest rate from 1% to 0.15%. Life insurance companies that sell annuities have to earn rates on their investments higher than the rates they pay to annuity holders. And making this change, and this is why the bill comes, making this change will make it more likely that this type of annuity will continue to be offered in Virginia. The bill's been shared with the insurance industry and other interested parties. We don't know of any opposition.
Okay. All right, any questions of the patron? Is there anyone here that wants to speak, that feels desire to speak on a bill that passed the House 99-0?
If you're in the.
Anyone opposed? Move to report. All right, there's a motion and a second to report House Bill 44. All those in favor vote aye.
Ayes 15, no zero.
Ayes 15, nays 0.
Thank you, Mr. Chairman, members.
Okay, thank you, Delegate Blair. All right, the next is House Bill 62, Delegate Ward.
Good afternoon, Mr. Chair, members of the committee. House Bill 62 is a bill that's being introduced as the request of the State Corporation Commission Bureau of Insurance. The bill removes an outdated section that refers to statutes that no longer exist. The bill repeals a code section dealing with air trip accident insurance policies, which no longer are sold in the United States. And the bill also allows the Bureau of Insurance to notify industry representatives by email of new and withdrawn standard forms. This bill has no known opposition to this legislation, so I ask that we pass the bill.
All right, there's been a motion and a second to report House Bill 62. All those in favor of reporting House Bill 62, vote aye.
Ayes 15, no zero.
Ayes 15, no 0.
Thank you, Mr. Chair, members of the committee.
Okay, next is House Bill 78. That's Delegate Davis.
Yes, sir. Mr. Chairman, House Bill 78 comes after getting really annoyed one Saturday night.
What?
After getting really annoyed one Saturday night. So if you've ever had a service that you signed up online, but you couldn't figure out how to cancel because you had to call an 800 number that never was answered, this bill solves that. It basically says that whenever you sign up for a service online and you pay online, you should be able to cancel online. Now, there is an amendment, and if you would please move the amendment, I'll explain the amendment as well.
So moved, Mr. Chairman.
All right, it's been a motion second to adopt an amendment to House Bill 78. All those in favor say aye. Aye. Okay.
And Mr. Chairman, so what this does is some companies actually have marketing websites. They're nothing but a simple one page that is kind of a outward-facing marketing piece, but it's not connected to the main supplier. So the initial bill said you had to allow you to cancel on the website that you signed up on. The problem is it may have been one of those little marketing sites. So this just says that the supplier's website, where you go to pay your bill, that has to be the website that you're allowed to cancel on.
All right.
So moved.
All right, motion is second to report House Bill 78 as amended. Vote aye. Those opposed, nay.
You did good that time, Davis.
A Saturday night special, huh?
Yes, sir.
15,
Thank
no
you so
zero.
much. Appreciate it. I know.
All right, next is House Bill 82, Delegate Kilgore's.
Thank you, Mr. Chairman. This comes at the request of the Bureau of Insurance, and it amends the insurance holding provisions of the code to help the Bureau assess the financial strength of the entire holding company and not just a particular insurance company in that group. It uses a thing called the group capital calculation, and it looks at the liquidity stress test and all that. It really just gives our Bureau more tools. I do have someone here if there are any questions, but that's basically all it does. It comes at the request of the Bureau.
All right. Are there any questions of Delegate Kilgore, committee members?
Move the report, my man.
Hold on. Anyone out feels compelled to speak on behalf of this bill? Anyone opposed?
If you're,
All right, bill's before us.
Second.
All right, there's been a motion and a second report, House Bill 82. All those in favor vote aye.
Thank you all.
Ayes 15, no zero.
Ayes 15, no 0, bill's reported. Next bill is House Bill 95, Delegate Head.
Thank you, Mr. Chairman. House Bill 95 was brought to me by the folks at Department of Social Services, Adult Protective Services Division. There's some folks that around the Commonwealth have been having issues when an investigation of financial abuse is in place. There were some banks and other financial institutions that were a little reluctant to give the financial information to them when they're investigating that. And so that was the reason for bringing this bill, to say that folks have that they are allowed to have it. They technically are already allowed to have it. This is just giving a code section that they can go back to and report. There is, with this, however, an amendment that the bankers had suggested that I think the clerk has a line amendment for this particular bill. If the clerk could report that, if that's okay.
Mr. Chairman, Delegate Head, on line 123, after liability 4, insert 1, providing information or records to the local Department of Social Services or to a court-appointed guardian ad litem, or Romanet 2.
What line is that?
Line 123. So the sentence would read, absent gross negligence or willful misconduct, the financial institutions and its staff shall be immune from civil or criminal liability for, and this is added language, Romanet 1, providing information or records to the local Department of Social Services or to a court-appointed guardian ad litem, or 2, existing language, refusing to execute a transaction, delaying a transaction, or refusing to disperse funds pursuant to this subsection.
You said it line 123. My House Bill 95 only has 18 lines.
There was the engrossed version from the House.
Okay. So the bill was dramatically changed in the House?
There was a section added in the House that added guardians ad litem.
Okay.
As
Yeah,
well
I
as.
didn't get that. Okay. All right, that's fine.
So it wasn't a substantive change, it just added guardians ad litem as well as adult protective services.
All right, you've heard that. It's, I need a motion to adopt. I don't think we've adopted the amendment.
So moved, Dr.
All
Amendment.
right, there's been a motion to adopt an amendment to House Bill 95. All those in favor, say aye. Aye. All right, House Bill 95 is before us as amended. There's been a motion and a second to report House Bill 95. All those in favor of reporting House Bill 95, vote aye.
Ayes 15, no zero.
Okay. Delegate Head, you've got now House Bill 146.
Yes, sir, Mr. Chairman. House Bill 146 was brought to us from the folks at the Medical Society of Virginia and the Bureau of Insurance. We've worked on language for this, and what you should have before you now is a very much abbreviated version other than what was initially filed. It's down to just one paragraph. But the purpose for this was so that if anyone wanted to file a complaint against any of the insurance carriers, some of the providers had been reluctant to do that for fear of reprisal when they were in renegotiation, and this allows the Bureau of Insurance will now receive complaints from a third party and will be able to investigate from there. This is already a practice that they were setting up. Previously, their practice was that they would only accept the complaint from the covered person, so they were, again, concerned about coming forward. And so we worked this out with all the stakeholders and reduced it down to the version that came out of the House. And that is the bill. And I think we've got some folks here if anybody needs to have any questions and can address that.
First off, is anyone here on committee want to have a question to ask the sponsor? All right. Those in favor, quickly.
Thank you, Mr. Chairman. Scott Johnson for the Medical Society. I want to thank the Bureau of Insurance because this does codify a recent change in their practice, and I also want to thank the health plans for working with us.
Right.
I know of no opposition. Be glad to take your questions.
Okay. All right. I assume then there is no opposition. All right, the bill, was there an amendment to this since it
No,
got
sir.
over here? All right.
Move
House
report.
Bill 146 is before us. I need a motion and a second.
Move report.
There's motion and a second report. All those in favor of reporting House Bill 146, vote aye. Opposed, nay.
Ayes 15, no zero.
Ayes 15, no zero. It's reported. And next, Delegate Head, you have House Bill 263.
Yes, Mr. Chairman, members of the committee, this is a very interesting bill. Cryptocurrencies and the cyber currencies have become such an emerging part of our economy. And we realized back in the fall that banks were not allowed to be the custodians of those currencies. Some of the federal banks now have been given that capability, but our state chartered banks were not. If you're not familiar with cryptocurrencies, it's all in the cloud, but you have to have certain keys and utilize, generally speaking, a third-party source that is also in the cloud. And this would give it to the trust departments to be able to hold assets for folks. We would be the first state in the union to actually take the steps to codify this. A lot of folks are certainly interested in it and are watching this legislation very anxiously and encouragingly. And I think the folks from the Bankers Association are here with us as well. This will give us a great competitive advantage from an economic development standpoint.
Mr. Chairman,
Senator Spruill.
what is crypto money?
Bitcoin, Ethereum, Dogecoin, those sorts of things that you're hearing so much about.
And it's in the cloud.
It's all in the cloud. I don't understand how it works, but it sure is important stuff, and it's worth a lot of money now. So,
By the way, before we go any further, I just was informed on Delegate Byron's bill, which came out of here 15-0, it has to go to Finance Committee, and he's just going to write that into the motion. So we don't have to go through the recall, okay. Just wanted you all to know that. All right. Okay, Senator Marston.
Thank you. Delegate Head, do you know whether this cryptocurrency, you always hear about the value of a bank, it's X number of billions of dollars and what have you. Does that fit neatly into the calculation as to, what the holdings of that bank are, or are they going to be two separate kind of?
as I understand it, and there's somebody from the Bankers Association here that could perhaps clarify this if need be, but my understanding is, think about this in terms of being like, working like a safe deposit box, so that it wouldn't be part of the bank's assets or anything for the valuation of that. It would just be simply that the bank would be allowed to hold the keys that would allow you to have access to make transactions.
Okay.
All right. Any other questions by the committee of the paper? All right, those in the audience want to speak in favor of the bill. All right, each side, if there are two sides, will have 2 minutes. So go ahead.
Mr. Chairman and members of the committee, Heather Derflinger with the Virginia Bankers Association. We support House Bill 263, and we appreciate the delegates' leadership on this issue. The bill provides the authority to allow state-chartered banks to offer the traditional custody services that banks have been providing for years, but now for the evolving asset class of virtual currency. While not every bank may be willing to offer these services at this time, this bill would allow our member banks to provide these services as the market continues to evolve. We appreciate the forward-thinking approach of this bill, as it allows Virginia banks to go ahead and get ahead of the curve by allowing our member banks to meet the needs of our customers in a safe and secure manner. We hope that you support the bill. Thank you.
Okay.
Mr. Chairman, could I ask the witness a question?
Senator Bell. Ma'am, you want
to? Thank you, Mr. Chairman. It's a little bit of a follow-up to the last question, because I'm reading, I like the concept. I think it's a good idea, and it will help us with this rapidly expanding area. The question I've got is, it covers in the bill, acting on line 35, it says that they may either provide custody service in a non-fiduciary or fiduciary manner, and then later on it talks about the requirements for fiduciary. Wouldn't that not be the same per Senator Marsden's question earlier, where they would have to basically would be part of the assets under management?
I do not have an answer to that question at this time, but Matt Bruning with the Virginia Bankers Association is in the queue. And I think he would be able to answer that question.
Thank you, Mr. Chairman. I don't know if we can go to him now or not, but I mean, again, I'm fine with it, but I think just as a fiduciary, this would affect the assets. A non-fiduciary would almost be like a safety box, safety deposit box.
All right, is there anyone in opposition to the bill?
Mr. Chairman, we have an individual wishing to speak via Zoom.
Matt?
Matthew Bruning, please begin your testimony.
He's usually over here.
Mr. Bruning, please begin your testimony. Mr. Chairman, he appears not to be here.
Pardon?
Mr. Chairman, there seems to be a Zoom issue.
Okay. All right. I guess that's it. Bill's before us.
Mr. Chairman, move the report.
All right, there's been a motion and a second to report House Bill 263. All those in favor of reporting 263, vote aye.
I want my money out of the damn clouds. I want you to know that.
Me too, Senator Spruill.
Ayes 15, no zero.
Thank you, Mr. Chairman.
All right. All right, next is House Bill 309, Delegate Rasul.
Thank you, Mr. Chairman, members of the committee. There is a technical amendment offered by the State Corporation Commission.
Mr. Chair, Delegate Rasul, on line 81, after year insert, for the purpose of determining the projected excess of fees and the actual fees collected under this section, the Commission, for any prepaid annual registration fee paid in accordance with subsection H, shall include only the portion of the prepaid annual registration fee attributable to the year to which the fee pertains.
I'll move the amendment.
Second.
All right, there's been a motion and a second to adopt the amendment. You just heard Mr. Stevens. All those in favor of adopting the amendment, say aye.
Aye.
Aye. Opposed? All right, amendment's adopted. You want to go ahead and explain that a little?
Thank you, Mr. Chairman, members of the committee. What we have before us is a bill to help reduce some red tape for small businesses. This permits domestic and foreign LLCs to prepay their annual registration fees for 2 or 3 years, similar to the way that we do our DMV registrations, where we can do it for 1, 2, or 3 years.
Right.
This would allow you to prepay your LLC registrations for 1, 2, or 3 years.
I see. Okay. It's pretty simple. Senator Marsden.
Thank you. Delegate Rasul, the prepayment, do you know how often or how frequently registration fees are raised?
How often they're raised? Mr. Chairman, Senator Marsden, I do not. I think that is up to the State Corporation Commission or through us. As far as the LLC registration fees, I think it's been pretty consistent for LLCs, for most LLCs at $50 right now.
Yeah, one of the companies I'm involved with, the law firm that does it, they just do it automatically every year and just bill me or us.
So we would not be caught in a situation where by paying early you avoid potential increase. Is that correct?
Well,
Mr. Chairman.
Well, you've got to remember, companies pay it at different times of the year. You know, it's when you first started paying it as an LLC. You follow me?
Yeah.
Mr. Chairman, Delegate, Senator Marsden, I've had an LLC for maybe 15, 16 years, and it's been $50 for the whole time.
Yeah, it never changes.
Yeah.
Mr. Chairman, I just wanted to make sure that, I see that there's fiscal impact of $200,000 and there wasn't a Senate companion, so I would imagine this needs to go to finance.
Mr. Chairman.
Hold on. Tom, have you got anything on that?
Mr. Chairman, we did not receive a letter on this bill.
Mr.
Hobie, you have any? All right, apparently it doesn't have to go to finance.
And Mr. Chairman, Senator Bell, this is because it stays in an internal fund that does not impact general funds.
Right.
So it stays in an internal, what they call a cardinal fund, and all of it.
All right.
Second.
All right, there's a motion and a second to report House Bill 309. All those in favor of reporting 309, vote aye. Those opposed, nay.
Ayes 15, no zero.
Ayes 15, no zero. It's reported.
Thank you, Mr.
All
Chairman.
right, you're welcome. All right, next is House Bill 561. Delegate Scott. Welcome, Delegate Scott.
Thank you, Mr. Chair, members of the committee. This bill is a Code Commission recommendation. I'm on the Code Commission, and after reviewing certain parts of the code regarding corporations and regulated business entities, there are some issues, some areas of the code that needed to be set out, and some obsolete sections of the code that needed to be corrected, and some language needed to be cleaned up. This is a technical amendment only. It doesn't change any substantive parts of the code. It's a technical amendment only. There's no fiscal state impact on the State Corporation Commission. And so I'd entertain any questions that the committee may have.
All right, motion and a second to report House Bill 561. All those in favor, vote aye. Opposed, nay.
Thank you, Mr. Chair, members of the committee.
Ayes 14, no zero.
All right. Next is House Bill 606, Delegate Bourne.
Thank you, Mr. Chairman, members of the committee. House Bill 606 was a request by the State Corporation Commission. The bill simply removes the residency or citizenship requirement for personal property appraisers. This requirement's been in the code for many, many years. However, these property appraisers are not licensed in Virginia. Real estate appraisers who are licensed in Virginia, but they do not have any such residency or citizenship requirement. And this just sort of levels the playing field. I'd be happy to answer any questions, but if they're...
So they no longer have to be citizens or residents of the Commonwealth?
Correct.
Okay. All right, you've heard the bill. Is there anyone feels need to speak in favor or opposed to the bill? All right, bill's before us. All right, a motion and a second to report House Bill 606. All those in favor, vote aye. Opposed, nay. All right, whoops.
Mr. Chair,
15, no zero.
thank you for your time.
Okay, thank you. All right. All right, next is House Bill 652, Delegate Wampler.
Thank you, Mr. Chairman. Members, House Bill 652 seeks to solve one issue at the Virginia Employment Commission. The bill requires, it's 3 lines on 154. It says that prior to any individuals receiving benefits under chapter, Commission shall conduct an incarceration check and an employment status check. As the committee is well aware, we gave away over $1 billion in benefits in 2020 and 2021. Many of those are being litigated in appeals right now. If we did this check prior to giving away benefits, I think the state would be in much better financial position and agency position at the VEC. And that's the bill.
You mean we were giving unemployment benefits to people in jail?
Yes, Mr. Chairman. There's a few documented convictions across Virginia, one in Richmond, one in Norfolk, and I think there's one ongoing in Southwest.
Mr. Chairman, I think it was $42 million that was given to incarcerated people.
Is that right? Is there anything going right over there at VC? All right, thank you, Delegate Wampler. All right, you've heard the bill. There's a motion to report 652.
Second.
And a second. All right, all those in favor of reporting House Bill 652, vote aye. Opposed, nay. All right.
Ayes 15, no zero.
All right, next is also Delegate Wampler, House Bill 689.
Thank you, Mr. Chair. Members, House Bill 689 is a workers' compensation bill. What this bill does is 3 things primarily. First, and primarily, it moves the cap for any of these accommodations spelled out in the bill from $42,000 to $55,000. And secondly, it ties it to inflation. Third, Mr. Chairman, it adds scooters to the list of devices that can be used in workers' compensation claims. And that's the short. I can go much longer if needed.
Chairman?
Hold on.
I will add that the trial lawyers and the Bureau of Insurance have reached agreement on this.
Don't mess it up. Don't mess it up.
Senator Spruill.
Mr. Chairman, once you call a lawyer, you done lost my vote. You said lawyer. Don't call a lawyer's name. The part about scooters, explain that to me, the scooters part.
Yeah, so, Mr. Chairman and Senator Spruill, we have these modifications listed in the first section of the bill. That's lines 15 through 21. These are the things that can be furnished following a successful workers' compensation claim to the individual that's been hurt or incapacitated or debilitated. The reason we're moving the cap up is to help make some of these modifications at home. Cost of living going up, cost of goods going up, cost of labor. Many people that are disabled by a workers' compensation event can't make these modifications under the current $42,000 cap. The scooters addition speaks directly to the need of incapacitated individuals and disabled individuals. They often need a scooter to get around.
Mr. Chairman?
Senator Spruill.
Is this a lawyer's bill? You can tell me. I won't tell nobody.
No, this bill is supported by the trial lawyers, and the Bureau's got agreement with it as well.
Thank you, sir.
Yes.
Mr. Chairman,
Who pays for the cost of the scooter, as an example?
people buy workers' comp insurance. Mr. Chairman, question, making sure is it raised to 75 or 55,000?
55.
Mr. Chairman and Senator, it should be 55,000 in the bill. The introduced version was 75. We amended that down to 55.
Because on LIS, I think it's still showing the old one. Do we need to move anything for that? You got the right one? Okay, I must have hit the wrong link.
Mine shows that.
Mr. Chairman, a follow-up question. How long has been since we raised it last time?
Mr. Chairman, Senator, I believe it was 2012 was the last time that this was amended. And so with this bill, it also ties this number to inflation at 55. And so hopefully none of us will have to carry an amendment in the future.
Second.
All right, you say employer duty to furnish. So the employer has to furnish all this?
The employer would Mr. Chairman, the employer would pay its workers' compensation insurance, and the insurer would pay for the modifications.
They would do it. Okay.
Yes, sir.
Yeah. All right, you've heard 689. Is there a motion?
Second.
All right, there's a motion and a second to report House Bill 689. All those in favor vote aye. Opposed, nay.
Looking out for lawyers, bless your
All
heart.
right.
That's 15-0.
Ayes 15, nays 0. The bill is reported.
Thank you, Mr. Chairman, members.
All right, 691 is Delegate King.
Thank you, Mr. Chairman, members, and this is not a lawyer's bill. It also has nothing to do with the cloud, so my friend Lionel can relax a little bit.
Not you, Jay. You all right?
Mr. Chair, this is a bill that was requested by the State Corporation Commission. Last year, I carried legislation that made a number of different updates on the non-stock corporation, on the LLC Act, and other business law sections. We're working with the Virginia Bar Association, and this time, this bill does some cleanup with some of the language that was in the enactment clause of that bill to make sure that it doesn't expire when the enactment clause expires. But it makes a few other technical changes, but that's really essentially what it is. And if you have questions, technical questions, we have representatives from the State Corporation Commission, but otherwise, these are fairly routine technical changes.
Okay, are there any questions of the paper? Move the report. All right, well, first, is there anybody in the audience have an opinion?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
No speakers. There's a motion and a second to report 691. All those in favor, vote aye. Hey, you're knocking into my chair while I'm writing.
Ayes 15-0.
Ayes 15, nays 0.
Thank you, Mr. Chairman. Thank
you. All right, next 790, Delegate LaRock.
Thank you, Mr. Chairman. I'm sure I don't need to elaborate on the idea that we brought collective bargaining to Virginia in 2021. I'm aware that it's the chairman's initiative that brought it to us. The problem that House Bill 790 seeks to address is that there is some difficulty in achieving proper level of discipline between when members of the law enforcement community engage in alleged misconduct. The bill proposes to limit the collective bargaining agreements to between local governments and law enforcement. This is not an idea that I was conceived of myself. A study from 2020 United States Conference of Mayors titled Report on Police Reform and Racial Justice brought forward some pretty amazing bullet points showing that 50 cities restrict interrogations by limiting how long officers can be interrogated, who can interrogate them, and the types of questions that can be brought up in the interrogation, sometimes delaying interrogations up to 30 days. Another bullet point is that 41 cities give officers under investigation access to information that civilian suspects don't get. 64 cities limit disciplinary consequences for officers, including preventing an officer's history of past misconduct from being considered in future cases. So again, I reference studies. I have several listed here with the highest level talking points, but I won't take the time of the committee except to just cite that, again, according to this report on police reform and racial justice, over the years, police, quoting the summary, over the years, police contracts, unions, CBAs have evolved into much more than standard labor agreements. They cover the expected areas, hours, wages, benefits, but many have grown to include substantial barriers to basic accountability. We want to make sure that our officers have due process rights, but CBAs often contain provisions that go far beyond what is necessary to protect those rights. So, Mr. Chairman, I don't need to elaborate on current events that, okay, thank you.
All right, is there anyone who wants to speak on behalf of the bill? Anyone want to speak in opposition?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now.
We have one in opposition. All right, Governor Rock, you understand the sides.
Oh, yeah.
Yes, Mr. Chairman and members of the committee, Doris Kraus-Mays with the Virginia AFL-CIO, and we oppose this bill on the simple fact that we think all workers, if they want to form a union and have one, that they should. I will also address one thing and say this. Collective bargaining and police accountability, they're not mutually exclusive. A contract is not a shield for brutality, and in fact, a negotiated union contract may be a tool to help change protocols and the daily actions of how police interact with the people that they serve. And labor, the National AFL-CIO, we've been very involved in making sure to try to change culture. Thank you.
Thank you very much. Next.
Hi, Julia Newton with SEIU, and we oppose this bill. Thank you.
All right, bills before us.
Shall I move the PBI?
Motion and a second to pass by indefinitely.
Have somebody in the virtual room.
Oh. All right, let's give Mr. Nichols a chance.
That's female.
Excuse me.
Vic Nichols, please unmute and begin your testimony. Vic Nichols, please unmute. Last call, Ms. Nichols.
Thank you. Yes, there was a pause on the switchover. I support this bill. The fact is, the mayors have put it out. There is a good reason for this. Unions are not exactly the best way to solve the issues that have been brought up. And definitely the mayors looked at it, and this is what they have come to. So I suggest that we take a good hard look at that, and because unions do not solve every issue. Thank you.
All right. Is that it for Toby? All right, I would remind everybody that the collective bargaining bill that I passed a couple years ago was strictly local option. They don't have to negotiate with unions, okay? All right, bills before us. Do I hear a motion?
Report.
All right, there's a motion to report. Is there a second? All right, there's a motion and a second.
Move to PBI.
There's a motion, substitute motion to PBI. Is there a second? Motion and a second to pass by indefinitely House Bill 790. All those in favor of passing by indefinitely, vote aye. And those opposed, nay.
Thank you, Mr. Chairman.
All right.
Ayes 12, noes 3.
Ayes 12, noes 3. Bill is defeated. All right. All right, next is House Bill 912. It's Delegate Orrock.
Good evening, Mr. Chairman, members of the committee. This is very straightforward. Section 1 bill. The problem I'm trying to address is one that I think we've all experienced in my community. I know we've experienced it 3 to 4 times in the past 3 to 4 years, where that local insurance carriers, the contract expires with a local health care provider, and the clients then have no insurance protections to go to that local facility. They have to travel great distances or pay out of pocket. This is simply asking the Bureau of Insurance to look at the matter and see if we can find a way to address it in a comprehensive fashion without changing the world, if you know what I'm saying.
Okay, any questions of the patron? All right, is there anybody in the audience who feels compelled to speak?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, there are no virtual speakers.
Move the report, Mr. Chairman.
There's a motion and a second to report House Bill 912. All those in favor of reporting 912 will vote aye. Those opposed, nay.
Ayes 15, noes 0.
Ayes 15, nays 0.
Thank you, Mr. Chairman, members of the
Right,
committee.
yeah, thank you, Delegate Orrock. Okay. Next is Delegate 932, House Bill 932, Delegate Robinson. Sorry, Delegate Robinson.
That's okay.
Apologize.
Well, it's all good. It's all good. So
Well, at least I didn't call you Agent 007.
that'd have been okay.
Yeah.
They get to have a lot of fun, right?
There you go.
So House Bill 932, it extends the date from December 31st, 2021 to December 31st, 2022, the date by which COVID-19 causing the death or disability, excuse me, of a healthcare provider is presumed to be an occupational disease compensable under the Workers' Compensation Act. I know of no opposition to this bill, and I'll let our nurses and healthcare workers know that we have their backs during these difficult times.
Okay. All right. The bill's before us. Motion and, do I need I hear a second?
Second.
Motion and a second to report House Bill 932. All those in favor, vote aye. Those opposed, nay. Well, somebody vote Marsden. No, okay.
Hold on.
Okay.
All right.
Ayes 15, noes 0.
Thank you, appreciate
Ayes
it.
15, nays 0, bill is reported. All right. The next is House Bill 1027, Delegate Tran.
Thank you, Mr. Chair and members of the committee. I do have, I believe, 4 line amendments.
Tom, do you have those?
Yes, Mr. Chair. The line amendments, Mr. Chairman, Delegate Tran, on line 46, after obtained, strike a certificate of. On line 49, after any, strike misspelled judgment, insert correctly spelled judgment. On line 114, strike unfair, misleading, deceptive, or fraudulent acts, validity, insert validity, so changing the
Title.
catch line of that section, and then line 116, strike subsection A.
Second.
All right, there's a motion and a second to adopt the amendments. All those in favor, say aye.
Aye.
Opposed? All right, the amendments are adopted. You want to now present the bill, tell exactly why it's needed and what it does and why it's needed.
Sure. Thank you, Mr. Chair. So this bill offers new protections for small businesses, particularly Main Street mom and pop businesses and those owned by immigrants who are using merchant cash advances, which are an avenue to access capital, but could be potentially predatory. So merchant cash advances, they're an alternative financing agreement between a financial institution or company and a business, where the business, based upon their projected sales, the finance company buys out parts of their projected sales, so they give like upfront cash for those projected sales. It could be a percentage of estimated credit or debit card sales. It could be a fixed sum of money based on an estimate of sales. The payback mechanisms can be pretty complicated, making it difficult for our small businesses to understand. Some cases, they have higher interest rates, sometimes up to 300% higher than other small business loans, traditional bank loans, and even business credit cards. They do not need, currently, there are no federal or other state policies that regulate merchant cash advances. And so what this bill does is it requires MCA lenders to register with the State Corporation Commission. It requires them to provide the terms of the agreement in plain language to the business owner, and we delineate what those disclosure requirements are. It ensures that any arbitration or court actions that are going to take place in Virginia, and also that the upfront arbitration costs are covered by the MCA lender. And it allows the Virginia Attorney General to seek to enjoin violations of this chapter. And so we have, this issue was brought to me initially by a lawyer in Northern Virginia who's working with Vietnamese American business owners who had gotten caught up in an MCA. And we have since found out that there are local restaurants that are Black owned here in Richmond that have taken out an MCA and then taken out more MCAs in order to try to pay back and have gotten into an incredible amount of debt. So what this bill attempts to do is allow Virginia to put our arms around who the MCA players are in Virginia, since we don't have any ideas, through registration.
What does the M stand for again?
Merchant cash advances.
Advance, I knew that.
And then it allows us to be clear in what the contracts and terms of agreements are, so that our small businesses have a much clearer sense of what they're agreeing to and how much they'll owe at the end of the day. And it seeks to provide some additional protections if there are any kind of court actions.
Okay. Is there any question? We need to adopt the line amendments.
So moved. Second.
All right, there's a motion and a second to adopt the amendments. All those in favor say aye. Aye. Opposed? All right, the amendments are adopted. Are there any questions of Delegate Tran on House Bill 1027? All right, those who wish to speak in favor of the bill, come on up here. Give each side 2 minutes. How's that? You got time for that, or?
I wasn't sure which side, if there was multiple sides, that's all.
You're in favor? You support the bill?
I support the bill.
Okay. Well, go ahead and tell us.
Okay.
Give your spiel.
Mr. Chair, members of the committee, Nicole Brenner with Reed Smith on behalf of the Small Business Finance Association and the Retail-Based Finance Coalition, both of whom are associations with member finance companies who offer loans, lines of credit, and sales-based financing, as is regulated in Delegate Tran's bill. This was not our bill, but we have worked with the patron over the last several weeks. She has listened to us and addressed a number of our concerns. We think she's made a number of amendments that both strengthen her bill and make it workable. She has a registry provision, a ban on confession of judgments, broker disclosures. We support all of those provisions, in addition to the amendments that are before you today. We learned today that there are additional amendments that were brought to the patron and to members of this committee. If the committee considers those, then I'd like the opportunity to respond to them, but I won't take your time yet.
Well, we adopted them.
additional amendments that I think this gentleman behind me might want you to consider.
Oh, okay.
I'm good right now.
Okay.
So if you would like to consider those, I'd like the opportunity to respond to them. Thank you.
Mr. Chairman, may I ask her a quick question?
Yeah, Senator.
So
Mason.
from no regulations to this point to this regulation, and you've worked with her to square that up?
Yes, sir. Throughout the last several weeks, the patron has been generous with her time and addressing our concerns, and I think strengthened the bill with a number of good provisions.
Thank you.
All right, those opposed?
Still supporting.
You're still supporting?
Yes, sir. My name is Christopher Grimm. I represent the Innovative Lending Platform Association. We support this bill with
You represent who?
the Innovative Lending Platform Association. We're a trade association representing online small business finance providers and servicers. Our members offer all the products in the space, including sales-based financing or merchant cash advance. We have two amendments to this bill. We know we're late to the parties. We appreciate the sponsor sort of talking with us. Our two amendments are, one is to clarify on the broker disclosure. It just is really, really broad and would encompass what a provider would pay to advertise on Facebook or to run Google ads.
Did you submit the amendment?
Yes, we did.
Who has it?
We shared it with the patron's office earlier today. I don't know if others have seen it or not.
Mr. Chairman?
Tom, do you have it?
Mr. Chairman, did the patron agree to the amendments or not?
So, Mr. Chair, I would respond to Delegate Bell Senator Bell by saying, on the second proposal, I do not agree. On the first, I think we're trying to kind of think through what it means to I believe it would limit the disclosures that brokers have to provide around fees that they're receiving, compensation they're receiving, and I'm not sure that is beneficial to the small businesses. I understand the point that Mr. Chris Grimm is bringing up by if it's like a Facebook ad, for example, but there might be other examples where a provider has an agreement with a broker to steer potential clients to that provider, and I would think that would be good to know, but I'm going to stop.
Mr. Chairman?
Senator Spruill.
I think the picture of a bill, and you come at the last minute to bring in amendments, like everybody else, you give the pictures early and work it out. Not come here and, in my opinion, at the last minute to get us to an amendments to an patient's bill, and she's trying her best to explain why not. Because she's in fear of her bill, and I think it was right. It's not right for us to approve in amendments right at this point when you can do it today. Give it to the office today, and then come before us today trying to put amendments on this. So, Mr. Chairman, I'm hoping that any amendments at this point, late in the game, I'm hoping that we turn them all down.
Mr. Chairman, I know we have somebody in the queue, but there are no amendments before us. There's nothing been submitted we can look at, so I don't think we have amendments. I'm ready to make a motion on the bill.
All right, there's a motion.
I would like to finish if that's okay, Mr. Chair. I'll be very, very quick.
Go ahead.
So the other issue that we would like folks to consider, again, I understand we're late to the party. I don't want to waste anyone's time.
Really?
There are a number of other states that have laws like this on the books that require slightly different metrics. And if state requires more than what's required here in Virginia, we would like a path for those forms to be approved for this disclosure.
So without these amendments, do you still support the bill?
We do, because we support disclosure through and through.
Well, you might see how it goes for a year and talk to her next year.
Yep.
Mr. Chairman, I move the report as amended.
There's a motion.
Thank you, everyone.
Report as, you got speakers. All right.
Phil Hernandez, please unmute to begin your testimony.
Thank you, Mr. Chairman, members of the committee. I'll keep this very quick. Phil Hernandez with the Commonwealth Institute. We support this legislation and thank Delegate Tran for carrying it.
Thank you. Motion and a second to report as amended, House Bill 1027. All those in favor vote aye. Those opposed, nay.
Ayes 15, no 0.
Ayes 15, nay 0. The bill is reported.
Thank you, Mr. Chair and members of the committee.
Okay. Thank you, Delegate Tran. All right, next is 1091, Delegate Wilk. Virginia Public Procurement Act, project labor agreements.
Thank you, Mr. Chairman, committee members. Yeah, before you is House Bill 1091 dealing with project labor agreements. And in 2020, the General Assembly approved those for the state.
My bill.
You're well aware of that, Mr. Chairman. Mr. Chairman, I would add that nationally, 6 other states statutorily authorize the use of PLAs on public work projects, and all have established criteria requiring the public body to first determine whether the PLA is in the public's best interest. Virginia is the only state that statutorily authorizes PLAs without establishing objective criteria for their use. Mr. Chairman, committee members, for as an example, there was a PLA put forward in Pennsylvania back in 2017. There were some contractors that challenged the PLA, said it was unfair, so on and so forth, and the court ended up ruling in favor of the contractors. And so what we're trying to do here is put some guardrails on the requirements when the public bodies start putting the idea together, that they take into consideration, a myriad of things: the cost, complexity, quality, maintenance of skilled labor force, whether it's veteran-owned, minority-owned, women-owned businesses. And so, Mr. Chairman, that is the gist of the bill. Just asking that we put some guardrails, some safeties for the taxpayers, because they're the ones footing the bill for these projects.
Any questions of the patron? All right, anyone in the audience want to speak in favor? Give each side 2 minutes.
Mr. Chairman, good evening. I'm Gordon Dixon with the Virginia Transportation Construction Alliance. As you know, with the PLA legislation 2020, we're in uncharted territory. This bill is not about whether you're in support or you're opposed to PLAs. This is about guidelines and trying to mitigate or limit the potential of lawsuits that may come before that. As Delegate Wilt referenced, there are 7 other states that have had courts that have said PLAs are viable if you have guidelines that are in the best interest of the public, that have been established by that public body. We are not saying what the public body has to say or as far as what those guidelines are. They will determine what those guidelines are going to be. But the idea behind this is to protect some localities from potential lawsuits going forward.
They can go ahead and do this now.
Correct.
Establish their own
Yes,
guidelines now.
they could, and if they do, they probably are going to invite some lawsuits that were going to say that PLAs are arbitrary and capricious and are going to be held up and delayed as a result. And that's kind of what Delegate Wilt was referencing, the legislation in Pennsylvania where they went ahead and just implemented a PLA and said not only just a PLA, but this labor union specifically can work on the project or will get the project arbitrarily. And as a result, the courts there said, that's not the way it should be done, and there hasn't been a PLA in Pennsylvania since.
Okay, next.
Yep.
Mr. Chairman, members of the committee, Brandon Robinson with the Associated General Contractors. For many of the same reasons you just heard, we support this bill. It does not roll back the ability to do PLAs. And I would just further point out, in addition to the other states who have guardrails, the federal government also has guardrails. In fact, the President Biden's recent executive order on PLAs mandating them from federal projects has many of the same guardrails you will find in this very bill. So Virginia would be the absolute outlier if we were to go forward without any kind of guardrails on our PLA. So for that, we ask you to support the bill. Thank you.
Okay, those want to speak in favor of in opposition to the bill.
Mr. Chairman, members of the committee, Greg Ackerman with the DC Metro Building Trades. Just to speak briefly on some of the points that were made, the PLA in Pennsylvania was actually struck down based off entirely different set of criteria. As the gentleman mentioned, it was struck down because it preferred one labor union to another, and that's not what this bill does at all. What this bill unfortunately would do is it would actually open up state and local governments to a series of lawsuits, because if a PLA does not meet these criteria at any point, then any contractor association could actually sue the local government. So it would create a set of circumstances whereby local governments and state agencies would feel disincentivized from using PLAs. As the gentleman also mentioned, the president recently signed an executive order mandating the use of PLAs on federal projects over a certain dollar threshold. If we would like to mandate PLAs in Virginia, then we would be happy to discuss a set of criteria. But currently, this is optional. It's project by project, and so unfortunately, we would not support the bill.
Okay, next.
Good evening. First, I want to thank this committee for all the work it is performing. Thank you, Mr. Chairman. My name is Lou Spencer. I'm a resident of Virginia, and I'm the Assistant Business Manager with United Association Local Union Number 5, Plumbers and Gas Fitters. We are an affiliate of the Virginia Building and Construction Trades Council. Please oppose House Bill 1091. This bill places misguided restrictions on project labor agreements, or PLAs. PLAs, when properly implemented by construction users and contractors, encourage quality, harmony, and economy on fast-track, large, and complex construction projects. PLAs promote job site safety, decent wages, self-funded apprenticeships, health and retirement plans. PLAs promote coordination among the trades, working on site leading to top-notch craftsmanship. Lastly, let us remember the historic role dating back to 1930s that PLAs were used to build extraordinary national infrastructure and how they were used during World War II. PLAs should be encouraged, not unreasonably restricted. Please oppose House Bill 1091. Thank you.
I know this. I've been told that Bechtel and Lane will not do any road project that requires a bridge or a tunnel of any length, size, without a PLA. I also know that when we redid the interchange at 495, 395, and 95, that was done without a PLA. My understanding was it was supposed to cost under 600 million. It wound up costing over 800 million, was late, and several lives were lost. On the hot lanes, Transurban used a PLA. It came in 6 months ahead of schedule and 400 million under the estimate. So, I mean, they can't be all that bad.
Yeah, Mr. Chairman, I don't disagree with you. We're not trying to do away with PLAs.
Right.
We're simply trying to put some language as safeguards to make sure that our localities are protected for
All right,
lawsuits going forward.
All right, the bill's before us.
Mr. Chairman,
Senator Deeds.
I move we pass the bill by indefinitely.
There's a motion to pass it by indefinitely. Anybody in the Zoom room? Jason Parker.
Jason Parker, please unmute and begin your testimony.
Thank you. Can you hear me?
Yeah.
Jason Parker, Virginia State Building Construction Trades Council. We also oppose the legislation. These are optional project labor agreements, not mandated. Thank you, sir.
All right. Motion?
I made a motion to PBI.
Motion is PBI. There's a motion and a second to pass by indefinitely. All those in favor of passing this bill by indefinitely, that's House Bill 1091, vote aye. Opposed, nay.
Ayes 12, noes 3.
Ayes 12, noes 3.
Thank you, Mr. Chairman, committee, for your consideration.
Okay, House Bill 1151, that's Delegate Adams.
Yes, sir. Thank you, Mr. Chair. HB 1151 came to me from a constituent. This seeks to update the Lemon Law, also known as the Motor Vehicle Warranty Enforcement Act. This would allow autocycles to be included into this Consumer Protection Act. As you probably know, the Lemon Law make sure that owners have recourse if they have had to make 3 or more repairs of the same problem during an 18-month period. And an autocycle is a 3-wheeled vehicle that looks like this, and it costs pretty much the same amount as a car.
All right. Is anyone, any questions of the sponsor by the committee? All right. Anyone?
Second.
All right. Motion and a second to report House Bill 1151. All those who are in favor of reporting House Bill 1151, vote aye. Those opposed, nay.
Thank you.
All right.
15-0.
Next is Delegate, is 11, House Bill 1162. Delegate Waxman.
Yes, Delegate Waxman, I'll make it easy. The name's pronounced like Waxman, just like Waxman.
Pardon?
Yeah, the name is pronounced like Waxman.
Waxman.
Just Waxman.
Okay.
Try to make it easy for you.
Thank you.
Yes, Mr. Chair, members of the committee, it's my pleasure to come to present House Bill 1162. There is an amendment that one of the stakeholders provided me earlier that I would like the group to consider and adopt if possible. I've got a hard copy here. I think that amendment's also in LS, if I'm not mistaken.
Mr. Chairman, Delegate Waxman, on line 79, after shall insert apply to drugs with an annual estimated per patient cost exceeding $250,000 for Romanet 2. So the sentence would read, nothing in the subdivision shall apply to drugs with an annual estimated per patient cost exceeding $250,000 or prohibit the identification of a 340B reimbursement request.
Move to adopt the amendment.
Second.
All right, there's a motion, a second to adopt the amendment. All those in favor of adopting the amendment, say aye.
Aye.
Okay, you want to explain now exactly what the bill does and why it's needed?
Yes, sir. The bill was brought to us by the Virginia Community Healthcare Association. They represent about 60 safety net providers. These are rural health clinics, federally qualified healthcare centers that serve approximately 361,000 patients in the rural areas of in Virginia. That's the reason they're called safety net. They go in and provide care where other healthcare providers aren't there. They take care of the medically underserved areas. In 1992, I believe it was, the federal government allowed them to purchase their drug products from a federal program called 340B. The federal government worked with the manufacturers. The feds were trying to figure out how to fund these rural healthcare centers. They went to the manufacturers, and the manufacturers offered significant discounts to those centers to use for their patients to help stretch their scarce medical resources. This also is a rather large revenue stream to those centers to keep going so they can fund other programs. Most of these programs, I'm told, that helps generate about 30% of their income. Recently, the third-party payers have started to send contracts for reimbursement for those prescriptions at a rate lower than they offer regular retail prescriptions. What this bill does is to try to stop that discrimination so the health centers' prescriptions that are purchased through 340B drugs get the same reimbursements that the retail pharmacies in the neighborhood get for those same drugs. What this bill does is it protects those rural safety net providers. It protects some of the contract pharmacies that those centers contract with to fill those prescriptions for their patients. It keeps some of the pharmacies that those centers actually own now, as well as this protects those centers. My fear is if they lose this income stream, some of those rural areas will lose those health clinics. And I do have some representatives here from those groups to speak, if you like.
Okay. Any questions of the patron by committee? All right, those who want to speak in support of the bill, welcome.
Thank you, Mr. Chairman and members of the committee. I'm Michael Jackson, and I'm representing the Virginia Community Healthcare Association, and we'd like to thank Delegate Waxman for carrying this bill. There are a few people that are in the Zoom room that would like to speak, so I'm going to make my comments brief.
Okay.
Number one out of 19 Virginians receive their health care from one of the 28 federally qualified health centers.
One in how many?
1 out of 19.
19.
So 1 out of 19 Virginians receive their health care from a federally qualified health center, which there are 28 of across the Commonwealth. Secondly, the funding model that the federal government constructed for the federally qualified health centers sits on 3 legs. 1, direct funding. Once every 3 years, these 28 health centers apply for a grant, receive direct funding. 2, they also receive FTCA, Federal Tort Claims Act, so they don't have to purchase their malpractice insurance from the open market. 3rd is actually they receive enhancements from CMS, which includes the 340B program. So as a covered entity, these safety net providers are eligible to participate in the 340B drug program. 3rd, all of the health centers' program income Any income over expenses is required by grant provisions to be reinvested in the program, to see more patients and provide the same patients with expanded services. With that, I'm going to ask that you support House Bill 1162, and I would like to allow individuals from our federally qualified health centers in Zoom to talk.
Quickly, because time is rapidly being used up.
Elizabeth Early, please unmute and begin your testimony.
Hi, my name is Betsy Early, and I'm at Harrisonburg, the Healthy Community Health Center in Harrisonburg, Virginia, and we completely support this bill because it will allow us to continue to provide services to the Harrisonburg and Rockingham community. And it is a federally supported program, but it is not taxpayer driven. It allows the benefit to stay, and this bill that Mr. Waxman has before us allows us to continue to keep the benefit in the health center instead of at the PBM level. And so therefore we completely support.
Thank you.
David Christian, please unmute and begin your testimony.
Thank you, Mr. Chairman, members of the committee. Again, I'm David Christian. I'm the Pharmacy Director for Central Virginia Health Services. We are a federally qualified health center serving 45,000 patients a year. Central Virginia Health Services also operates 2 in-house pharmacies and approximately 100 contract pharmacies that we work with every year. I appreciate the opportunity to speak in support of House Bill 1162. Federally qualified health center pharmacies have been targeted by PBMs and health plans, reducing the payment of those drugs purchased through the 340B program. This is done by addition of 340B language in the contracts, reducing payment on these drugs. The 340B program is crucial for the federally qualified health centers. Our grant requires us to apply all generated revenues back to the mission of the health center. We are not lining pockets of stockholders, but rather offering much needed health care to underserved areas. The health center relies on this program to offset the
wrap
cost
it up.
of healthcare. So we support this bill. Thank you.
Thank you.
Kathy Bryant, please unmute and begin your testimony.
Good afternoon, Mr. Chairman and members of the committee. I'm Kathy Bryant at Blue Ridge Medical Center Pharmacy and Blue Ridge Medical Center in rural Nelson County, Virginia. And we too support this House Bill 1162 that ensures healthcare access for our patients. We use the savings realized by participating in this program in order to provide not only medical, but also behavioral health, dental, and medication assistance program. So thank you so much for considering this.
Okay. All right. Thank you all very much. Is there anyone opposed to the bill? All right. Bill's before us. All right. There's a motion and a second to report House Bill 1162. All those in favor vote aye. Opposed, nay.
Ayes 15, no zero.
Ayes 15, nay 0. The bill is reported.
Thank you, Mr. Chair and members of the committee.
Okay. Next is House Bill 1178, Delegate Avoli.
Thank you, Mr. Chair. What does HB 1178 do? It directs the Department of Labor and Industry to disseminate information regarding seizure first aid to all employers in the Commonwealth with 25 or more employees, and requires these employers to physically post this information in a prominent location in the workplace. The bill incorporates a good faith Samaritan provision of the Code of Virginia that shields a person from liability when rendering emergency care in good faith under these circumstances. This poster, the Epsilon Foundation provides these signs in 14 different languages for free, and they can go to the website and basically print it.
Delegate Avoli, has anybody suggested that they have any opposition to this bill?
I have no opposition to the bill whatsoever. No,
I
sir.
move to report.
All right, motion and a second to report 1178. All those in favor of reporting House Bill 1178 vote aye. Those opposed, nay.
Thank you, Mr. Chair. Thank you, members of the committee.
Ayes 15, no zero.
Ayes 15, nay 0. The bill is reported. And our last bill is House Bill 1237. That's Delegate Lefwich.
Thank you, Mr. Chairman. Taking a cue from the last bill, there is no opposition to this bill.
Just to be clear.
It's a really simple matter, Mr. Chairman. 6.2-1000 defines trust business, and then there are several exceptions to trust business, one of which are attorneys at law And all my bill does is say that that the exception applies to attorneys at law or an entity wholly owned by attorneys.
So, Mr. Chair, so if you're a lawyer that prepares a trust, you're not doing trust business?
Yeah, this came up when the Commissioner of Accounts in Portsmouth refused to allow a law firm to qualify because it's not an attorney.
Move to report.
Well, hold on. Let's
a lawyer
bill. You got two lawyers green already. There you go. You explain to me the different. I'm hearing what you're saying. I don't know what you're talking about.
Right.
Explain to me what you're talking about, please.
So, when you qualify to administer an estate,
Give me an example as a trust business. That's
an attorney could administer an estate, and what this is saying is that a law firm wholly owned by attorneys could do the same thing that one attorney could do, under the exception in the statute.
Mr. Chairman?
So one
since-
attorney doing that is a trust business, but a whole law firm is not?
That's what the Commissioner of Accounts, that's the position he took in this particular case, that what one attorney can do, a law firm cannot do.
Mr. Chairman?
And so thus, we're trying to clarify that an attorney is the same as a group of, an entity wholly owned by attorneys.
Second question, Mr. Chairman?
Yes, sir.
Now, so the client, will it cost me more money whether I have one attorney or a client, a whole, same amount of money?
No, sir.
This lawyer's bill again?
It is a lawyer bill.
Bless your heart. Thank you.
Mr. Chairman, how many lawyers does it take to change the light bulb? I withdraw. I move to report.
Second.
Motion second. I can tell you how many Virginians it does. Anyway, all right, there's a motion, a second to report House Bill 1237. All those in favor say aye, or vote aye. Those opposed, nay.
I think the committee.
Ayes 15, no zero.
Ayes 15, nay 0, it's reported. All right, is there any other business come before the committee? If not, the committee will rise.